Hey, thanks for tuning in to our video. You've clicked on this because you're interested in how you restore gun rights. How do you restore firearm rights if you have a felony conviction? My name is Attorney Keith Williams. I'm based in Greenville, North Carolina, and I'm here to answer that question today. If you have a felony conviction and you want to restore your gun rights, you want to restore your firearm rights, how is it that you can do that if you have a North Carolina felony conviction? Now, I have to say at the beginning of this video, nothing that I say today is legal advice. In order for me to give you legal advice, you would have to retain me to represent you, and I could look at your specific situation. But I am going to give you general observations about the law under North Carolina state law, also under federal law. I'm licensed to practice in North Carolina, so I'm here to talk about North Carolina state law and also federal law. Again, restoring your gun rights after a felony conviction. For a long time, we could do that to restore firearm rights after a North Carolina felony conviction by expunging the North Carolina felony conviction. Sometimes you hear that referred to as an expunction, sometimes you hear it referred to as an expungement. It's the same thing. And here in North Carolina, if you have a North Carolina felony conviction, we have a North Carolina statute that we can use to file to expunge your North Carolina felony conviction. North Carolina General Statute 15A-145.5. If you have a low-level felony conviction, a Class H or a Class I, a low-level nonviolent felony conviction, then very often we can file a petition under this statute to expunge that felony conviction. Now, there is a waiting period, typically 10 years if you have one felony, typically 20 years if you have 2 or 3 felonies. But if you meet the waiting period and you meet the other requirements, then we can file a petition to expunge the state North Carolina felony conviction under this state law, this North Carolina law. And for the longest time, if that was done, then the federal authorities would accept it. Why? Because if you look at federal statute 18 U.S.C. 1921, 18 U.S.C. 1921, it defines what the federal authorities treat as a conviction. And under 18 U.S.C. 921, it says that if a person has a felony conviction and the state that convicted them has expunged that felony conviction, then the federal authorities will accept that expungement as sufficient also for federal law. So as we talk about restoring firearm rights, it used to be that if we get the state felony expungement, that would not only restore the state rights, but it would also be accepted by the federal authorities to restore the federal right to have a firearm. And you say, well, what's changed? Well, here's what's changed. We have this interplay of state law with federal law. And again, talking about if you have this felony conviction, a North Carolina felony conviction, and you're trying to restore your gun rights. We had this interplay between state and federal law. If the state grants the expungement, the federal authorities would respect it. But what's changed within about the last year or so, at the time that we're doing this video, is that the federal authorities now take a different view of a North Carolina state felony expungement order. And let me explain to you why that is. North Carolina's felony expungement laws have some exceptions in them. They have some exceptions that are set up especially for a person who might get an expungement today and then turn around and get in more trouble tomorrow. There is a sense that that person shouldn't be able to still benefit from their expungement. And so if they turn around and get in more trouble tomorrow and they get prosecuted for that, a North Carolina state prosecutor is allowed to go into the expunged felony conviction and use it against the person in their new case. That's an exception to the North Carolina expungement law that says otherwise the case is expunged. There are other exceptions to the North Carolina expungement law. For instance, if a person has a felony expungement and then later they go to apply to work in law enforcement, the Law Enforcement Certification Board can also look at expunged cases as they decide whether they want to hire this person as a law enforcement officer. So you think of it like a block of cheese. If the cheese is whole, then the expungement order is whole and it's accepted by the federal authorities. But when the cheese becomes Swiss cheese, because it's got lots of exceptions in it, it's not a whole thing anymore. In fact, it's got holes shot all through it. It's got exceptions shot all through it. What has happened is that the federal authorities have looked at that and they've said, hey, under federal law, that's no longer good enough to qualify as an expungement. North Carolina's state expungement law has too many exceptions in it, too many ways that the so-called expunged case can come back later and still be used against the person. And so within the last year or so, the federal authorities have sent word that they will no longer accept a North Carolina felony expungement as enough to restore the federal firearm right. You say, well, that's bad news. What do we do about that? Well, fortunately, North Carolina, separate from the expungement law, has a separate statute that talks about restoring firearm rights following a felony conviction. It's a whole separate statute. It's not an expungement statute. It's not a statute to expunge a felony conviction, but it's a statute to restore rights for a person who lives in North Carolina so that they have the firearm rights going forward. That statute is a different one. It's this statute here, North Carolina General Statute 14-415.4. North Carolina General Statute 14-415.4. That's the restoration statute. And that's what we need to do now for somebody who has a North Carolina felony conviction who wants to restore their gun rights following that felony conviction. We don't go to the expungement anymore. We go to a petition to restore their rights under North Carolina General Statute 14-415.4. Now, that statute has a lot of requirements. It has a 20-year waiting period, not a 10-year waiting period. It makes clear that the person, when they were convicted, they couldn't have had a gun or had firearms or any kind of violence that was involved with their case. There are a lot of exceptions or conditions that go into the restoration statute. But if you meet the requirements of the restoration statute, then we can file a petition in North Carolina State Court to restore your firearm rights. And if the North Carolina State Court grants that, then it's my understanding that the federal authorities will also accept it, and that it will be what you need to be able to restore both the North Carolina right to be able to possess firearms, as well as the federal right to be able to possess firearms following that North Carolina state felony conviction. Now you say, well, what if I'm not a resident of North Carolina? Can I still apply for this? And as written, the statute says that it's limited to residents of North Carolina, because I think the idea is this is only to restore rights within the state of North Carolina. But if you're a person who has a North Carolina felony conviction and now you live in a different state, then it may be that we can argue that that residency restriction, that state level restriction, is unconstitutional, that it's a burden on your federal constitutional right to travel from North Carolina to other states, that you shouldn't be penalized just because you've left the state. Because let's say you live in some other state, let's say you live in Missouri, and you have a North Carolina felony conviction, but you think it might help you in Missouri if North Carolina restored your firearm rights. Well, I think the argument can be made that you should be able to apply for restoration even though you're no longer a resident of North Carolina, so that potentially that could help you in your other state. Now, of course, you would have to talk to a lawyer in the state where you live. In my example, it was Missouri. You would have to talk to a Missouri lawyer to tell you if that would help you. But if you think that would help you, then I think that's an argument that can be made. And that's also something that we could take a look at with the restoration petition. So to summarize it all, it used to be that a North Carolina felony expungement was enough to restore not only the state right, but also the federal right to be able to possess firearms. That has changed because North Carolina's felony expungement law has too many exceptions in it. It's like Swiss cheese now. And so in order to restore a person's firearm rights effective in both North Carolina and at the federal level, we need to file a petition to restore firearm rights under 14-415.4 following that North Carolina felony conviction. If we do that, then it's my understanding that the federal authorities will accept that. Hey, you've watched all the way to the end of the video. If you have any questions, feel free to give us a call. You're on our website. You're welcome to send us a contact. You see our phone number, 252-931-9362. We're based in Greenville, North Carolina. We're about halfway between Raleigh and the Outer Banks, and we would be glad to work with you. Thanks for watching.